Hello, friends. I welcome you all to this 42nd session of Law of Evidence. Today, we are going to see two important sections, section 110 and 111. 111A also we will study, and as usual, let us have a brief overview as to what all we are going to study in this session. So, first, we'll see on whom burden of proof, as we are seeing the burden of proof chapter. On whom burden of proof as to ownership lies, that who has the burden of proving that he is the owner. Then on whom burden of proof of good faith in a fiduciary relationship lies. So if something has happened in fiduciary relationship, that is a relationship of confidence and trust, then on whom the duty that whatever was done in good faith would lie. So as usual, we'll see as we have seen balance of payment 101 to 3, Nescafe and Yes 104 to 106, dealer 107 to 109. Today we'll see the off part, the burden of proof of Nescafe dealer of Patna. So off 110 deals with ownership. The person, it is presumed that the person who is in possession is the owner, and if anyone claims that, provided that possession is as an owner. So, if a person claims that the person in whose possession the thing is not the owner, then it is upon him who claims that he is not the owner the burden of proof lies. We'll just read it. Burden of proof as to ownership. When the question is whether any person is owner of anything of which he is shown to be in possession. So suppose this is house and say A is shown to be in possession of this house. So when the question is whether any person is owner of anything of which he is shown to be in possession, and A claims that he is the owner, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. So if A is in possession and A claims ownership, but B claims that A is not the true owner or A is not the owner, then in that case the burden of proof lies on B, that is on that party who claims that the person in possession is not an owner. So what is important here is that possession raises a presumption of ownership. Presumption of ownership. But three things are very important here in order for this to happen. One, it should be actual physical possession. That is, the person should A should actually physically occupy it. So actual physical possession is important. Second thing which is necessary is that the possession should be as an honor. So if A is holding it as a tenant, then he is not the owner. So possession should be as honor. And third important thing here is that it is not limited to only immovable property, but it covers both types of property, that is movable property as well as immovable property. So burden of proof as to ownership is on that person who claims that the person in possession is not the owner. But this possession should be actual physical possession, It should be possession as an honor, and it should cover both movable as well as immovable property. Next is section 111 or 111, which is good faith. So if a transaction between two persons has taken place and one person is in fiduciary relation with the other, that is, one person is such that he is a type of having type of trust and confidence in another, then it is said that the burden of proving that there was good faith is on that person who is the superior or on whom the other person depends. So we'll just read section 111. Proof of good faith in transaction where one party is in relation of active confidence. So there are two parties, one who is superior and another who is dependent, you can say. So this way the relationship between two is not that of equality. So they are not equal. Rather, he is some way dependent upon him. That is, this person is dependent on his superior. So where there is a question as to good faith of a transaction. Now there is a transaction between these two, and the question is realizes that whether it was done in good faith or not between parties, one of whom stands to other in position of active confidence. That is, they are not equal. The burden of proving the good faith of transaction is on party who is in position of active confidence. So burden of proving that there was a good faith lies on the person who is superior. So the good faith of sale by a son just come of age to father is in question in a suit brought by the son. So suppose he is a father and he is son, and there is a dealing between the two. Son has just come of age means son has just become the major. Now the question is whether the transaction which was done between father and son is that of good faith or not. So in that case, as father is in a superior position, so father will have the burden of proving the good faith. So the burden of proving good faith of transaction is on father. Now, same question applies, same type of relationship applies between the, say, parent and child. We have already seen parent and child, they are in fiduciary relationship. Fiduciary relationship, as we have already seen, is a relationship of trust and confidence. So where one party has got trust and confidence in the other party. So like parent and child relationship, lawyer and client relationship, then spiritual guru and their followers, because they also come under influence, and principal and agent, they are also not of equal stature, and partners and the firm, the doctor and patient. So these type of relationship are those relationships where there is a fiduciary. So if there is a contract with a parda nasi woman, then in that case also there is a fiduciary relation, and the other party has to prove that there was the burden of proof that there was good faith is on that person. So this is off. Now section 111 is the A in the presumption of such an offense. It is that if the offense um, is under section 121, 121A, 122, and 123 of Indian Penal Code, or there is criminal conspiracy or attempt to commit or abatement of offense under section 112, 122, or 123 of Indian Penal Code. That is, if there is an offense that has been committed under section 100, 121, 121A, 122, and 123 of Indian Penal Code, or there is a criminal conspiracy or attempt or abatement of an offense under section 122 and 123 of Indian Penal Code. These are offenses against the state. Now, if now these first condition is that this type of offense should be there. Now that offense should be in a disturbed area. That the area must have been declared to be disturbed area. Any area declared to be disturbed area under any enactment for the time being in force, making provision of suppression of disorder and restoration of maintenance of public order. So why it is disturbed? Because there is a disorder, and what is required is that public order be restored. So first, in a disturbed area, first that the offense should be one of these offense mentioned in the IPC. Second, that this offense should be in relation to a disturbed area. Then, or there's one more or added to it regarding area. You can take it to A and this is to B. An area in which there has been over a period of 1 month extensive disturbance of public peace, or for more than 1 month that area must be in extensive disturbance of public peace. So in that case, so for a particular some particular offenses in some particular area, now if it is shown that a person was at a place, and at that time when that person was in that place, firearms or explosives were used to attack or resist member of any armed forces, and these armed forces should be charged with the maintenance of public order and they must be discharging their duty, it shall be presumed, unless contrary is shown, that such person has committed such offense. So three things should be there. One, there should be certain these specified offenses, that is, offenses against the state under section 121 and 122, 123, or their commit or their conspiracy or attempt or abatement. It should be in a disturbed area or an area where public peace is extensively disturbed for more than 1 month. Now, that person, what should happen is that firearms should be used to resist or attack armed forces who are trying to maintain or the public peace in that area. Now, in that case, if any person is shown to be in that area at that particular time, a presumption will be raised that he has committed such offense. However, it is shall, that is, court has no discretion. Court will have to presume it, yet it is rebuttable in nature. So these are some special provisions because sometimes it becomes very difficult for the police or prosecution to prove in case in such disturbed areas that particular person has done any offense. So this presumption has been made. There are more such provisions we will see in later lectures. So today we did basically three sections. Section 110, which says that honor ship lies with the person who is in possession as owner, provided he should be having actual physical possession. It includes both movable as well as immovable property. and the person who claims that the person in possession is not the owner, he has the burden of proving it that he is not the owner. Then, when there is a 111 says that there has been a transaction and person are in fiduciary relationship, that is relationship of trust and confidence, then the person who is in superior position has the burden of proving that there was good faith. And 111a, it says that if there is an offense in the section uh, 121, 122, 123 of IPC in a particular disturbed area or where disturbance is more than for 1 month, and arms have been used to resist or attack the forces who are discharging their duty to maintain peace in that area, and it is shown that at that particular time when armed forces were attacked, that particular person was in that area, then it shall be presumed by the court that he has committed such offense. However, it is shall that it is rebuttable in nature. That's all for today. Thank you, friends.